In United States v. Miller, the Supreme Court zeroed in on a fine detail in bankruptcy law. Section 106A says you can sue the federal government in certain bankruptcy fights. But the justices made clear that waiver only applies to the federal claim created by the Bankruptcy Code. It does not reach the state law claims that a trustee might borrow to build that case. Nine Robes uses non-partisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided. It's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. All Resort Group, a Utah-based business, became insolvent after its shareholders diverted $145,000 of corporate funds to pay personal federal tax obligations. When the company filed bankruptcy, its trustee, David L. Miller, sued the United States under 11 U.S.C.A. 544B. Section 544B allows a trustee to avoid transfers voidable under applicable law, here Utah's fraudulent transfer statute. The government argued that sovereign immunity barred any state law suit to invalidate federal tax payments. The Bankruptcy Court, District Court, and 10th Circuit each held that 6A's waiver of sovereign immunity with respect to 544 extended both to the federal SCI 544B cause of action and to the underlying Utah statutory elements, allowing the trustee's claim to proceed. Justice Jackson, joined by Chief Justice Roberts and Justices Thomas, Alito, Sotomayor, Kagan, Kavanaugh, and Barrett, reversed. The court explained that sovereign immunity waivers are jurisdictional. They permit courts to hear suits against the United States, but do not themselves create or expand substantive rights. Section 106A1 therefore waives immunity only for the federal 544B claim, not for nested state law causes of action. Section 106A5 unambiguously provides that nothing in Fact 106 shall create any substantive claim for relief or cause of action not otherwise existing. Moreover, Fact 544B expressly requires the trustee to identify an actual creditor capable of avoiding the transfer under external law, a requirement Congress omitted in Fact 544A. Construing 106A to obliterate that element would undermine decades of practice and run headlong into the canon that waivers of sovereign immunity must be construed narrowly. There were no separate concurrences. The court declined to decide an alternative theory pressed by the trustee, that an actual creditor under Utah law might have avoided the transfers by suing the individual shareholders rather than the United States, and remanded that question for further proceedings. Justice Gorsuch dissented. He argued that at 106A1, unqualified waiver of sovereign immunity with respect to 5544 must permit trustees to bring any A544B claim free from immunity defenses, including those to the state law elements. Denying that remedy, in his view, conflates the defense of sovereign immunity with the merits of the underlying claim and departs from Congress's intent to let trustees step into the shoes of creditors under applicable law. Section 544B empowers trustees to avoid transfers that unsecured creditors could void under external applicable law, typically state fraudulent transfer statutes. That actual creditor requirement aligns the trustee's powers with those of private creditors and limits disruptive clawbacks. By contrast, Sec. 544A allows avoidance without an actual creditor prerequisite, reflecting a deliberate congressional design. Section 106A waives sovereign immunity jurisdictionally to permit avoidance actions against government-held tax liens under Fact 544A, where no actual creditor is needed, and 54B suits against consenting state governments. It does not, however, alter Fact 544B's substantive contours or negate state law conditions for avoidance, a result compelled by the text, structure, and long-standing rule that immunity waivers must be construed narrowly. Find us online at ninerobes.ai. That's the number 9robes.ai. Like and share this podcast with friends that like to be informed. 9robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.